The suit was dismissed?
Suit was decreed
Okay.
against the judgment of reversal. I am the plaintiff. Suit was filed against the defendant under Rent Act for eviction of the defendant on account of default in payment of rent, bona fide personal necessity.
Yes.
Now, case of the plaintiff is that the suit property was originally held on possessed by one Jagu Saw, Jagu, Jagu Saw,
Sahu?
Saw, S-A-O, who died leaving behind his son Chedi Saw.
Chedi Sahu.
And Chedi Saw died leaving behind his wife and 4 sons.
Yes.
And one son of Chedi Saw is Jibodhan Saw.
जी बोधन
Yes.
स्पेलिंग बताइए.
Jeobodhan.
Sa.
Jibodhan Saw also died, leaving behind 4 sons and his widow, namely Pati Kuar, P-A-T-I, Pati Kuar.
Yes.
Now, the suit case of the plaintiff is that suit property, there was partition between all the legal heirs of Chedi Saw, and the suit property was allotted to Virender Prasad Saw, Ramesh Saw, and Dukhni Devi. Virender Prasad Saw and Ramesh Saw are 2 sons of Chedi Saw, and Dukhni Devi is wife.
So suit property was allocated to
Two, two sons and wife.
Ramesh.
Virender Prasad Saw and Ramesh Saw and Dukhni Devi.
Ramesh Birendra.
Ramesh, Virendra and Dukhni
Dukhni Devi was?
is wife of Chedi Saw. Chedi Saw is the son of Jagu Saw, only son of Jagu Saw. Now,
Excellent. ये plaintiff का केस है.
ये plaintiff का केस है.
The learned counsel for the appellant has submitted that, as per the case of the plaintiff, the suit property belonged to Jagu Saw, whose son was Chedi Saw, and Chedi Saw died leaving behind his wife, Dukhni Devi, and 4 sons. Amongst the 4 sons of Chedi Saw, one was Jibodhan Saw, who also died, leaving behind his wife, Patti Kuwar, and 4 sons. It was a specific case of the plaintiff that there was a partition amongst the legal heirs of Chedi Saw, and the suit property was allocated to Ramesh Saw, Virender Saw, both sons of Chedi Saw,
My lord.
and to Dukhni Devi, wife of Chedi Saw.
My lord. Now, these 3 persons, Ramesh, Virendra and Dukhni, they transferred the suit property to one Jaitu Nisa by virtue of registered deed of sale dated 21/4/1989.
Jaitu Nisa.
Yes.
Jaitu. Nishan.
My lord.
Registered.
Jinatun, I'm sorry, Jinatun, Jinatun, Jinatun Nisha, Jinatun.
Jinatun
Nisa.
Nisa. Registered sale deed.
Yes, by virtue of registered sale deed dated 21/4/1989.
21/4/1989. 1989. He submits that Ramesh Saw, Virendra Saw and Dukhni Devi, Dukhni है ना?
Minor.
Dukhni Devi jointly sold the suit property to one Jinatun Nisa, JINATUNNISHAN, by virtue of registered sale deed dated 21/4/1989.
Now this purchaser, Jinatun Nisa, also sold and transferred the suit property to the plaintiff by virtue of registered deed of sale dated 8/8/1990.
Which was then sold by Janatun Nisa to the plaintiff by virtue of registered sale deed dated 8/8/1990. The plaintiff came in possession of the suit.
Yes. Now the defendant name is Om Prakash Saw. Om Prakash Saw. He is son of Jibodhan Saw. Jibodhan Saw was son of Jechedi Saw. And
Yes.
there was further specific pleading that one suit was filed for against Jinatun Nisa, title suit number 58 of 1990. Now,
Om Prakash Shah is defendant number 1.
Om Prakash Saw is defendant.
Only
one, yes.
The sole defendant, Om Prakash Saw,
Yes.
is son of Jyobodhan Saw. Okay?
Now, only one correction, my lord. There is fault on my part, my lord. The suit property was partitioned between Chedi Saw and all his sons and the legal heirs of the deceased Jibodhan Saw. I may be permitted to stand corrected.
उसमें तो amongst तो नहीं बोले.
नहीं बोलेंगे, लेकिन क्योंकि छेदी साव जो एक है वो भी पार्टी थे उसमें.
The learned counsel has submitted that वो भी छेदी साव भी पार्टी.
हाँ, उस पार्टीशन में छेदी
The
साव भी
learned counsel has submitted that in the previous partition, Chedi Saw himself was a
party.
and the property and the entire property of Chedi Saw was partitioned amongst his sons, including Jyobodhan Saw.
Well, including legal heirs of Jibodhan, because Jibodhan was also
Including legal heirs of Jyobodhan Saw,
yes.
since Jyobodhan had expired prior to Chedi Saw.
Well, now one suit, well, title suit number 58 of 1990 was filed by against Jinatun Nisa.
Who filed it?
This suit was filed by Chedi Saw and one another person, Chedi Saw and Nageshwar Saw, one of the son. Two persons filed suit, my lord. Chedi Saw and Nageshwar Saw.
Whose son?
Nageshwar Saw is son of Chedi Saw.
The learned counsel submits that one title suit number 58 of 1990 was filed by Chedi Saw and his son, namely Nageshwar Saw,
Yes.
against Jainatun Nisha
Yes.
in connection with the suit property involved in this case.
And for declaring that the sale deed dated 21, registered sale deed dated 21/4/1989.
Seeking a declaration that the registered sale deed number 20, registered sale deed dated 21/4/1989, transferring the property
is ab initio void.
by Ramesh, Virendra and
Dukhni.
Dukhni to Jaitu Nisha is void ab initio.
Yes. Now this suit, Jinatun appeared, and in that suit, sale deed was challenged, suit was dismissed.
The learned counsel submits that the title suit number 58 of 1990 was dismissed
Now, in that suit, both the parties filed their pleadings, and there was a specific finding of the learned trial court that this is admitted case of the parties, that there is partition amongst all. It was recorded.
The
Now,
learned counsel has submitted that the title suit number 58 of 1990 was dismissed primarily on the ground that there was already a partition amongst Chedi Sao and his legal heirs and successors.
now thereafter, this Om Prakash Saw, who was also one of grandson of Chedi Sao, he was inducted as a tenant in the year 2002. He was inducted as
The learned counsel for the appellant has submitted that Om Prakash Sao, son of Jubodhan Sao and grandson of Chedi Sao,
Yes.
was inducted as a tenant in the suit premises.
Yes. Now the tenancy was oral and
By
with-
oral tenancy,
yes. Now, my lord, they paid rent, my lord, till August 2002.
and rent was paid by Om Prakash Sao
To this person, my lord, the plaintiff.
plaintiff का क्या नाम है?
प्लेंटिफ का नाम है फातिमा बीबी। फातिमा बीबी जो परचेज की जिनातुन से।
To Fatima Devi,
Bibi.
Fatima Bibi, who had purchased the suit property from Janatun Nisa by registered sale deed
Yes.
dated
8/8.
8/8/1990.
Yes. So there was two grounds. One was default in making payment of rent, and second was personal necessity, because son of the plaintiff had started legal practice, so he was in need of house for the purpose of his residence and chamber. It was specifically pleaded in the plaint.
The learned counsel submits that the suit was filed on account of default in payment of rent and also personal necessity, inasmuch as the son of Fatima Bibi became a practicing advocate, practicing right?
Advocates.
Became an advocate, and he needed the suit property for his residence and chamber.
Now, thereafter defendant appeared, he filed written statement and admitted that the property is owned by Jagusco because he was the grandson of Chedisau. He also admitted that yes, Chedisau had 4 sons, Dukni, his wife, but defendant denied that there was partition. Defendant said no, there was no partition, and I am also one of the co-owner of the suit property. I am not the tenant.
The learned counsel submits that the defendant appeared and admitted the genealogy, right?
Yes, yes.
Admitted the genealogy and also but denied that there has been any partition with respect to the suit property.
Yes.
And on account of absence of any partition, he asserted himself to be a co-owner of the suit property and thus denied the relationship of landlord and tenant
Okay.
with the parties.
So, on the basis of these rival contention, issues were framed. Altogether, 6 issues were framed. 2 issues was important. Issue number 3 was in relation to relationship of landlord and tenant, and issue number 4 whether the defendant can be evicted on the ground of default and
The learned counsel submits that on these rival contentions, the issues were framed and issue number framed as follows. Quote karna hai.
para number 4 of the trial.
Para 4 of the trial court judgment. He has further submitted that issue number 3 and 4.
3, only 3 is the relationship,
the issue number 3 related to relationship of landlord and tenant, and issue number 4
and 5 is regarding
4 and 5 was relating to default in payment of rent
and personal necessity.
and personal necessity respectively.
Yes. Now, my lord, the plaintiff filed the judgment of the suit, title suit 58 of 1990. It was exhibited on as Exhibit 8.
The learned counsel submits that the plaintiff had exhibited the judgment passed in title suit number
Paragraph 5
58 of 1990, which was marked as Exhibit 5,
8.
sorry, Exhibit 8,
Yes.
and its discussion is reflected from paragraph number
My lord, paragraph 11.
paragraph 11 of the trial court judgment.
Yes, no, my lord, reflected. Well, I'm sorry, my lord. Paragraph 5, my lord, will find of the trial court judgment.
Paragraph 5 of the trial court judgment, and has also
Also, my lord, adduced, my lord, order of the title appeal. Against that suit, appeal was preferred, and appeal was also dismissed for default.
he has also submitted that the title suit was subject matter of title appeal number. The judgment passed in title suit number 58 of 1990 was subject matter of title appeal number 41 of 1993, and the appeal was also dismissed.
Yes. Now, my lord,
The learned counsel submits that in such circumstances, the transfer made by Ramesh, Virendra, and Dugni Devi to Janatu Nisha by registered sale deed number 20, registered sale deed dated 21/4/1989 became valid and had become valid and binding on the parties by virtue of the judgment passed in title suit number 58 of 1990 and against which the appeal was also dismissed. यही बोलना चाह रहे हैं?
yes, yes, yes.
ठीक है, और बताइए.
Thereafter, my lord, the learned trial court, my lord, after going through the taking into consideration the evidence of PW1, PW3, and PW9, it came to a specific finding that there is relationship of landlord and tenant between the parties.
PWs.
Yes, sir. Plaintiff हम थे, plaintiff का.
The learned counsel submits that the learned trial court considered the evidence of PW1, 3, and 9 and has come to a specific finding that there was a relationship of landlord and tenant between the parties.
The learned trial court, my lord, in para 14, learned trial court has also taken note of evidence of this defendant who was examined as DW3 and regarding his cross examination. He was asked a specific query that whether he filed any suit for cancellation of the sale deed of Jaitu Nisha or the plaintiff, or whether he know about the title suit of 1990. He stated that no, I have not filed any suit, and he has also said, my lord, that he does not know regarding the title suit of 58 of 1990.
This is DW number.
DW3, paragraph 14 of the trial court judgment, it has been
The
determined.
learned counsel has also submitted that the learned trial court, while considering the aforesaid issues, has also referred to the evidence of DW3, who had categorically stated, who had expressed his unawareness in connection with title suit number 58 of 1990 and the judgment and decree passed in the same case.
And he has also admitted that he has not filed any suit to cancel the sale deed of Jaitu Nisha.
He also admitted, he also stated that he had not filed any suit seeking cancellation of the registered sale deed with respect to the suit property in favor of Janatu Nisha. That's it.
Yes, ma'am. Now, Lord, suit was decreed. The defendant preferred appeal. Title appeal, my lord. Civil appeal, which was numbered as, my lord. Civil appeal number, my lord, 29 of 2018.
2018.
Yes, sir.
2018.
Yes, sir. 19 of 19 of 2000, no, sorry, but 29 of 2018. सिविल अपील नंबर 29 of 2018.
सूट का क्या होगा?
सूट मेरा सूट डिग्री हो गया and it has been held that there is a relationship of landlord and tenant between the plaintiff and the
The
defendant.
learned counsel submits that the trial court decreed the suit after holding that there was a relationship of landlord and tenant between the parties, against which an appeal was filed being title appeal number 29 of 2018, which is subject matter of the present case.
Well, now,
Appellate court can-
yes, now in the appeal, the learned first appellate court has given a very perverse finding, holding that no, the plaintiff has failed to prove there was partition amongst the heirs of Jagusa.
The learned counsel submits that the learned first appellate court, while setting aside the judgment passed by the learned trial court, was of the view that the plaintiff had failed to prove
Prove the claim of partition
claim of partition
allegedly took place among the heirs of Jagusa. Internal page 13
which allegedly took place amongst the heirs of
Jagusa.
Jagusa.
Now there is, and further held that there is absolutely no evidence. Now,
And held that there was no evidence
Yes.
with respect to such partition.
and well, thereafter decided that defendant is the co-owner and there is no relationship of landlord and tenant because
And
yes.
the learned first appellate court, as a sequel to their aforesaid finding, was of the view that the defendant was
Not a
the co-owner of the suit property and was not a tenant in the property.
Yes. Because every plaintiff's witness was cross-examined on this point that whether defendant grandfather was owner of the property, whether the other person was as a co-owner. So evidently they were the co-owners. So it was accepted. Now my lord, I have, my lord, the certified copy of this judgment also. So the learned trial appellate court, my lord, has given a perverse finding, my lord, regarding issue of partition, that there was issue of partition. And moreover, there is in a case of eviction, my lord is well aware that the necessary issues are whether there is a relationship of landlord and tenant or not, and whether the landlord has proved the grounds for default. So, my lord, there was sufficient oral evidences, my lord, who have proved that there was tenancy. There was even documentary evidence, my lord, that which proves that there was partition, my lord. I have also brought the certified copy of that title suit number 58 of 1990, my lord. Paragraph 11 is very clear. It has been held by the earlier court. It is admitted case by both the parties that there was a partition.
And this Jagusa was a party?
Jagusa was the Chedisa.
Jyobodhan Saw was a party?
No, Jibodhan Saw was not a party. And but he has stated that I have not filed any suit for cancellation.
That is a separate thing.
Yes.
He had not filed.
No, he was not.
He was not a party.
Not a party.
He had not filed any
No.
case.
But other co-owners came in that suit, my lord, and they were examined. And thereafter, this
But how will it bind the plaintiff?
plaintiff bind.
How will he bind the defendant?
Defendant will bind by.
Because
He was claiming through Chedisa.
He was claiming through Chedisa.
Chedisa. He was grandson of Chedisa.
There was a partition amongst whom? Who were the parties in the partition?
Partition among Chedisa
And
and his sons.
sons means Jyobodhan Saw.
Jibodhan. Heirs of Jibodhan. Heirs of Jibodhan. And in that suit was filed by Chedisa. Now the question is in a suit for eviction on the ground of default and personal necessity. The mandatory adjudication was relationship of landlord and tenant. And once there was, my lord may kindly take the trial court judgment. There was a specific quoting of particular plaintiff's witness who has said what has said, everything has been recorded. The learned trial court came to a finding, no, the plaintiff has failed to prove any partition, any documentary evidence which could suggest that there was partition. And my lord, the learned trial court has held that he was the one of the co-owners. So in a suit for eviction on the ground of default and personal necessity, my lord, incidentally it can be touched, but my lord, it cannot be dismissed on the ground that there was partition or not partition. Rather, there were other evidences also, my lord, which shows that there was partition.
The learned counsel has submitted that the learned first appellate court has completely failed to appreciate that there was enough material on record to show that there was previous partition, including the judgment passed in title suit number 58 of 1990. Is there any finding that there was a previous partition in this
Yes,
case?
yes, there is a finding, that's all. Yes.
The learned counsel has submitted that the learned court has misconstrued Exhibit 8. The learned first appellate court has not considered the import of Exhibit 8. Exhibit 8 consider किया?
नहीं, it has not been considered. Kindly see, my lord will see, my lord. The finding starts from internal page 9 of the trial court's judgment. Issue number, is there any relationship of internal page 9 of the first appellate court's judgment? My lord has got it. Now, my lord, I read entire, my lord. This is the main point of the case. In this context, first of all, I want to refer the observation of the Honorable Court. In the case of such and such, reported in Honorable Court had pleased to observe that landlord in such a such.
Page number कौन सा part?
Page number, internal page number, my lord, 9 of the first appellate court judgment. Appeal वाले में.
This is the main point.
Yes. In such a suit, it is required to prove only two things to enable him to claim a decree for eviction against his tenant from the tenanted suit premises. First, there exists a relationship of landlord and tenant between the plaintiff and the defendant. And second, the ground on which the plaintiff landlord has sought defendant's tenant's eviction under the Rent Act exists. With these two things, when these two things are proved, eviction suit succeeds. It has been further observed by the Honorable Court that the question of title to the suit property is not germane for the decision of the eviction suit. The reason being, if the landlord fails to prove his title to the suit property, but proves the existence of relationship of landlord and tenant in relation to the suit premises and further proves existence of any ground on which the eviction is sought under the Tenancy Act, the eviction suit succeeds. Conversely, if the landlord proves his title to the suit premises but fails to prove the existence of relationship of the landlord and tenant in relation to the suit premises, the eviction suit fails. At last, the Honorable Court pleased to observe that in the eviction suit, the question of title or the extent of the shares held by the appellant and respondent number 1 against each other in suit premises cannot be decided, nor can be made the subject matter for its determination. Coming back to the present case, I find that admittedly the suit property was earlier owned by Jaggu Saw, the grandfather of the defendant. The plaintiff claims that a partition took place among the heir of Jaggu Saw, in which one half portion of the suit property was allotted to his son Chatti Saw, Ganesh Saw, and heirs of Jivodhan Saw, and other half portion was allotted to Birendra Saw, Ramesh Saw, and Dukni Devi. And through transfer by way of registered sale, the plaintiff obtained the one half portion of Birendra Saw, Ramesh Saw, and Dukni Devi. First of all, I find, my lord will God, this is important, that plaintiff has failed to prove the claim of partition allegedly took place among the heirs of Jaggu Saw. This finding is perverse.
नहीं, इसका कोई रेलेवेंस नहीं है.
नहीं है, वो तो नहीं.
इसका इसलिए रेलेवेंस नहीं है. Was there a partition amongst the legal heirs of Chatti Saw? This is relevant.
हाँ, this is relevant.
Because Chedi Saab had number of sons.
Yes.
Out of them, only some of the legal heirs had sold the property.
Yes.
Right?
Yes. And in the sale deed, there was the setter. Apart from there, that sale deed was challenged by one of the two possessors, Chedi Saab and one son challenged the sale deed of Jinatun Nisa. Challenged this sale deed. Same property was in question in earlier suit. Now, apart from it, my lord, why? Because I am saying that the finding of the trial court that there is absolutely no evidence, either documentary or oral, on record regarding this part of the plaintiff. Now, thereafter, and there is no doubt.
You see, there is no relevance of
Partition even also.
Yes, so how does that make it?
No, why I am saying, my lord, because there was a finding and this was my duty, my lord, to say exact picture of the suit and appeal. Now thereafter, my lords will find, so far as claim of tenancy is concerned, admittedly no written proof exists of the same, and hence only oral evidence is there for consideration, and as such the quality of evidence to prove the tenancy, in other words, the relationship of landlord and tenant is required of a high degree. Out of total 6 witnesses of the plaintiff, PW1 and 2 are formal one, and out of rest 4, 2 are sons and husband, respectively of the plaintiff. The plaintiff describes the boundary such and such. Thereafter, kindly one next page. PW3, although claimed that his own house is situated in western side of the disputed house where he resides along with his family, but his said claim does not find support either by plaintiff or by any other witness. I take pause, my lord. My lord, can you take this one, page number 11.
Second appeal में इतना नहीं सुनेंगे.
नहीं, हम क्या कहना चाह रहे हैं कि trial court has said that I will not give any importance to oral evidence. Why? Because the evidence is not pleaded in the plaint. Kindly see the PW third line. The PW3, although claimed that his own house is situated in western side of the disputed house where he resides along with his family, but his said claim does not find support either by the plaintiff or any other witness. Now, my lord, I take pause. Kindly take, my lord, trial court judgment. Kindly take.
He failed to describe the suit property also. He had nothing.
He has said. My lord, now kindly take internal page 13 of the trial court judgment. What appellate court has said, my lord? Appellate court has, yes.
To this extent, where he was residing is not relevant.
Not relevant. Now the question was only that whether he was one of the evidence to prove relationship of landlord or tenant. The trial court has taken same evidence, same witness, and he said, yes, there was tenancy. The landlord has given the suit property on rent, but the appellate court has, my lord, has not given any reasoning. What reasoning is given? That since there was no document to support evidence of partition, the evidence of PW3 is not written in the plaint. My lord, whether evidence are required to be pleaded in the plaint. Kindly take, my lord.
No, please don't pick up a sentence from.
No, thereafter, my lord, kindly see a further evidence, my lord. My lord, kindly take other PW4 and other PW5. PW4, my lord, kindly see a PW4.
No, you are not able to channelize your argument. आप ऐसे नहीं आप Your most important argument was that this judgment was not taken care of and the persons were parties to this proceeding. So, right? Who were parties to this proceeding?
Parties to the
proceeding, the suit.
This suit.
The previous suit.
Previous suit, my lord, Chedi Saab. He was father, my lord, kindly appreciate. My lord, kindly go through the, my lord, the own noting, my lord, where Chedi Saab was son, father, and there was partition between Chedi Saab, his wife, and other legal heirs. Now, sale deed of Jinatu Nisa was challenged by Chedi Saab and one son. And in that suit, on behalf of plaintiff Chedi Saab and one sons, other co-heirs came, except my vendor. They came and said that there was no partition. But thereafter,
So that judgment will not bind your vendor, no?
no, that will bind.
No, it will not bind this tenant, because tenant or the tenant was not a party in that proceeding, isn't it? Although he claimed to be a co-sharer, but he was not a party to this partition suit.
Partition suit,
This
title
title suit, yes.
Now, my lord, if it was so, my lord, whether the first appellate court should not examine, my lord, exhibit 8 and 9, my lord, whether the judgment passed by the learned first appellate court is perverse on account of non-consideration of exhibit. Had
No,
it
it becomes perverse only if it has a bearing.
it has bearing, my lord, because they were examined, they appeared as a witnesses.
Who appeared as a witness?
My lord, the other family members of Chedi Saab. Just, my lord, I will just answer this, my lord. Just, my lord, kindly grant me some time. I am sorry. I will soon. So even if, my lord, because he was not a party, now if my lord saying, my lord, that this cannot be considered, now, my lord, kindly take the evidences which proves the relationship of landlord and tenant, because there was a specific finding of the trial court. Kindly take, my lord, the judgment of trial court. Because, my lord, had it been a case that the appellant, plaintiff, was not purchaser, plaintiff was purchaser by virtue of registered deed of sale. Now his sale deed was not challenged. Now, my lord, kindly see the trial court findings, my lord. Kindly see, my lord. My lord, internal page 13, if my lord allow me.
Rent receipts were exhibited. Payment of rent is proved.
Payment of rent has been proved, my lord, by oral witnesses.
Is there any finding of payment of rent?
Yes, my lord, yes. There is a finding of the trial court. Internal page, that why I want to refer, my lord. Internal page 13, my lord. Payment of, my lord, will find the lowest paragraph.
Yes.
That internal page 13, lowest paragraph.
Whether it is established.
Yes.
What is this exhibit 1, 2, 3, 8 and 9?
My lord, this exhibit 1, 2, 3, these are the, my lord, sale deed. 8 was.
Where is the finding of payment of rent?
Payment of, my lord, this one, my lord. All witnesses of this is the finding. Heard the learned lawyers of the parties and peruse the report very carefully. My lord, got this line. Heard the learned lawyers of the party and peruse the report very carefully as per the plaintiff. As per the plaintiff, PW3, PW4, PW5 and PW6 of their respective deposition have supported the above pleadings of the plaintiff all witnesses of the plaintiff have supported the case of the plaintiff, especially PW3 and PW4, who are independent witnesses, have categorically stated that plaintiff has given the suit house 3-room dhaba at rate of 300 rupees per month to defendant on 1/6/2002, and they were present at the time of rent agreement of the said house. And the defense of defendant is disputing the ownership of property but fails to establish as his property, whereas plaintiff has all the papers related to disputed land. Further, it is also.
Where is the agreement? Agreement has been executed.
No, rent, there was oral agreement. There was oral agreement.
At the time of rent agreement.
Yes. It is also concluded that plaintiff has well established orally that defendant is residing as tenant in the property of the plaintiff. So there is a specific finding of the trial court. Now, my lord is also aware with regard to the provision contained in section 116 of Evidence Act, my lord. If any tenant, my lord, says no, he has no, my landlord is not my owner, then my lord, he cannot say so. And my lord, he has to first surrender the tenancy and thereafter he has to claim a suit, my lord. And that's why, my lord, I have referred, my lord, kindly see the specific cross-examination of defendant was taken note of the trial court, my lord. In internal page 12, my lord. In cross-examination, he has specifically admitted that he has not filed any civil suit to cancel the salary of Jaitunisa. Internal page 12.
Why should he file a suit? He is already in possession. He is already in possession.
He is already in possession.
He is already in possession, and you have not filed any eviction suit on account of any ground other than tenancy.
Well, only difficulty with the plaintiff that the plaintiff has given his property to a person who was in genealogy of the actual owner. Now, my lord, only whether, my lord,
A regular suit, you see, under such circumstances, a regular suit, there is a lot involved in this. Even prima facie finding of title would not have been given. Very difficult.
I am not saying because finding of title cannot be given in every.
Even in order to come to a landlord-tenant relationship, to some extent title can be seen, but not in such an intricate case.
So that is their matter. But whether oral evidence can be brushed aside, whether once I adduce one, if I have given any property, this is, my lord will try to understand, this is a case of the year 1990. My lord, at that relevant point of time, my lord, generally, my lord, what tenancy was created. And if I brought those evidences, my lord, who said that yes, we were present, we are the oral witness, whether oral evidence has no relevance. Whether oral evidence is no relevance at all, my lord.
You read the finding of the trial court. You heard. Yes.
Yes.
Heard
the learned lawyers of the parties and peruse the record very carefully. As per the claim, the PW3, PW4, PW5 and PW6 of their respective deposition have supported the above pleadings of the plaintiff. All witnesses of the plaintiff have supported the case of the plaintiff, especially PW3 and PW4, who are the independent witnesses have categorically stated that Plaintiff has given the suite house 3-room dhaba at a rate of rupees 300 per month to defendant on 1/6/2002, and they were present at the time of rent agreement of the said house. And the defense of the defendant is disputing the ownership of property but fails to establish as his property, whereas plaintiff has all the papers related to disputed land. Further, it is well established that by the plaintiff that she is the owner of the suit property by exhibited document exhibit 1, 2, 3, 8 and 9. It is also concluded that the plaintiff has well established orally that the defendant is residing as tenant in the property of the plaintiff. It is also concluded that disputed land is of the plaintiff as she has sale deed, rent receipt, title deed of her vendor, whereas the defendant have no paper except rent receipts, and thus it is concluded that plaintiff is the owner of the said land. It also appears from the judgment of title suit 58 of 1990, exhibit 4, that the northern portion was in portion of entire land and was in possession of Jinatun Nisha, and as such recovery of possession has been sought, which also proved that Jinatun Nisha through registered sale deed dated Itna acquired right, title and possession over the suit land, and thereafter plaintiff got right, title and possession over the suit house through registered sale deed number 9233 dated 8/90/90. There is no evidence to contradict the pleading of the plaintiff. Hence, from the above facts and circumstances, it can be safely inferred that there is a relationship of landlord and tenant in between the party to this suit. It is also the case of the plaintiff that her son, so and so, work as advocate at Landlord-Tenant, and he has need of the said suit house for his residence and office. Hence, the plaintiff has bona fide need of suit premises for residence and office of her son. In view of the above facts and circumstances of the case, and also from the discussions made above, the court comes to a conclusion that there is a relationship of landlord and tenant in between the parties to the suit, and the plaintiff reasonably and in good faith requires the suit premises for her son for residence and office. Accordingly, these issues are decided in favor of the plaintiff and against the defendant.
The mother, the son was examined, plaintiff was examined
Yes,
as PW.
the plaintiff's son was examined and his
The plaintiff was examined as PW.
the plaintiff's husband has been examined. Plaintiff
She has
husband,
not been examined.
plaintiff husband has been examined and son has been examined. Plaintiff has not been. Husband of plaintiff is PW6, Mohammed Ansari.
PW5, who is a son,
Yes.
he admitted that he did not know as to whether any written tenancy deed was made or not.
It was not.
Plus, he also admitted that his mother had not issued any rent receipt to the defendant.
So, he was in the year 2000, the rate it was given on rent.
PW6, who is the husband of the plaintiff and key player of the present case, failed to say the exact business
Yes.
of the defendant.
He was
They had
very
no
fair.
idea to what use the property was given to.
Godown, it was Godown, it was specific. But in Godown, what is kept, for what purpose, he has failed to say. My lord, he could lie, my lord, and say that yes, I have seen the rent receipt. But since it was oral tenancy, that's why, my lord, in cross examination, it was stated.
You see, both the parties had their evidences. Even the DW1 has supported who is the neighbor, right? He has also supported the case of the defendant. involves adjudication on title, not a case for landlord-tenant relationship.
My lord, that is true, my lord, but if there is oral, then my lord only.
No, oral evidences have been considered by the learned first appellate.
No.
Yes.
What first appellate has court discarded oral evidence on the ground that it was not pleaded in the plate first and second. My lord, can you see?
No, that is not the only reason. You just see the discussion of oral evidence.
My lord, one
page number 11.
My lord, can you see? P can choose only one line.
Only one line.
My lord, whether oral evidence, if there was material.
आप बताइए ना कौन सा oral evidence? You see, both the parties have given oral evidences in their support. Both the parties have given oral evidences in their support.
Just my lord, I will show you. Now, kindly see, my lord, page number 8. My lord, what is see while reversing the judgment of the trial court, what reasons have been given? Kindly see the PW6 का disbelief क्या बोल करके कि my lord, kindly see internal page, my lord, 11 of the first appellate court judgment. PW6, who is the husband of the plaintiff and key player of the present case, failed to say the exact business of the defendant. Kindly see, it is relevant to mention that as per the pleading of the plaintiff, the defendant had obtained the pursuit premises for the purpose of good hour. Only because that the one of the witness has not said exact business, my evidence has been discredited. What was the material evidence? Material evidence was whether there was tenancy between the parties or whether what was the business of the parties. My lord, the learned first appellate court, while sitting at first appellate court, has to examine the evidence of all the oral witnesses, my lord, very carefully. My lord, may call for the oral witnesses, my lord, evidence may be called for, my lord. PW5 का एविडेंस को डिस्कार्ड किए इस ग्राउंड पे कि he has admitted that his mother has not issued any receipt of rent. तो अगर PW5 का PW6 का इसी ग्राउंड पे हो जाएगा, then my lord, in any case, any landlord will not be able to, my lord, take back the property. The direct decision of the Honorable Apex Court, my lord, reported in 2015 in case of Tapas Kumar Gupta, my lord, versus State of West Bengal, where the Honorable Apex Court, my lord, after taking into consideration only oral evidence, only oral witnesses, my lord, has decreed a suit for eviction. And my lord will find how it has been treated by the First Appellate Court. First Appellate Court has started the my lord, adjudication with one finding that there is no document of partition which could prove that there was partition. My lord, all the Exhibit 8, Exhibit 9 has not at all even gone through. Both the learned first appellate court has not taken pain to consider Exhibit 8 and 9. अगर Exhibit 8 और 9 को consider करके कह देते कि नहीं ये हो है, मतलब then I have a different case.